hello, everybody. This is Physical John X, and we are presenting you with another video on international commercial arbitration in Ghana. So, you're most welcome. Okay, and to begin our session, we want to ask whether or not Ghana should have a standalone arbitration act. And to answer this question, we are going to peruse a feature article by Mrs. Prince Kojo Tabiri and Godwin Selassie Osu, available on GhanaWeb.com. And this article, among other things, outlines two arguments for either keeping Ghana's Alternative Dispute Resolution Act as is, alongside arguments for a separate arbitration act for Ghana. So again, you're welcome. Now, arbitration has of some time become a preferred method for resolving disputes in commercial and investment transactions globally. In Ghana, the ADR Act, Act 798, was enacted by the Parliament of Ghana to provide a comprehensive legal framework for arbitration, mediation, as well as other forms of alternative dispute resolution. The arbitration section of the Act aligns with international arbitration standards, particularly the UN CITRO Model Law on International Commercial Arbitration 1985 as amended 2006, and the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards 1958. So this is a little background to the Ghana's ADR. The environment. Now, regarding competition, international competitiveness, however, the evolving nature of arbitration in the UK Arbitration Act 2025 reform, it may be prudent to assess whether Ghana's ADR framework of 2010 remains competitive and effective. The article focuses primarily on arbitration and examines the alignment of Ghana's arbitration section of the ADR Act with international standards, as well as exploring potential reforms to enhance Ghana's arbitration landscape, making it more efficient, investor-friendly, globally competitive. Major contributions of the article. 1. It outlines key areas where Ghana's arbitration framework can align with international best practices. 2. It identifies gaps and challenges in Ghana's current ADR Act. Further contributions include policy recommendations and reform proposals to modernize Ghana's arbitration framework in line with global standards and trends, as well as an assessment of whether Ghana should maintain an integrated ADR Act or enact a standalone commercial arbitration act. Now, throwing more light on some of these four contributions, we begin with the first one, which is an alignment with international standards. and we seek to see whether or not the unique trial model law of 1985 and 2006 is being held in view by the Ghanaian Act. Okay, and we also try to see whether or not arbitration agreements from other jurisdictions are recognized by the Ghanaian law, which is positive. The Ghanaian ADR Act acknowledges both arbitration clauses and separate arbitration agreements as mandated by the UNCITRAL model law. Also, along the same line, competent principle, Ghana's Act allows tribunals to rule on their jurisdiction in Section 24, which aligns with UNCITRAL's jurisdictional autonomy principles. And then, any arbitral tribunal in Ghana will have the authority to determine its jurisdiction, particularly concerning A, the existence, scope, or validity of the arbitration agreement. B, the existence or validity of the substantive or container agreement. And C, whether the matters submitted to arbitration align with the arbitration agreement. Also, there is the provision for limited court intervention. So, the Ghanaian framework limits courts' involvement in arbitration, consistent with UNCITRAL model law's principle of minimal judicial interference. B, regarding enforcement of foreign arbitral awards, the New York Convention 1958. Ghana is signatory to the New York Convention and enforces foreign arbitral awards under Section 59 of the Act. Also, there are grounds for refusal of enforcement, and these align with Article 5 of the Convention. Example, lack of proper notice, invalid arbitration agreement, procedural unfairness. Again, in this same light, there is a practical issue. In some instances, Ghanaian courts have delayed the enforcement of foreign arbitral awards due to procedural hurdles. For example, in the case of Balkan Energy versus Republic of Ghana, PCA case number 2010-7, there was a dispute before an arbitration tribunal that was formed after a breach of a power purchase agreement between the government of Ghana and Balkan Energy Limited regarding Nosafo power barge in 2007. Enforcement proceedings extended over 2 years due to judicial review applications after the tribunal mandated Ghana to pay Balkan Energy damages of $11.75 million plus interest and costs. On the third strand, which is a comparison with UK Arbitration Act 2025 reforms, the authors notes: 1. It is important to note that Ghana's Act strengthens confidentiality obligations compared to the UK Act. The UK Act, however, does not explicitly provide the same level of protection. And 2. The UK's arbitration confidentiality requirement remains an implied duty and not statutory. Also, in Ghana, confidentiality is statutorily provided for under Section 34 of the Act, except otherwise agreed to by the parties. The arbitral tribunal is mandatorily required to make orders concerning confidentiality of the arbitration proceedings or any other matters in connection with the arbitration, and may take measures for protecting trade secrets and confidential information. Again, the 2025 UK Act gives arbitrators express powers to summarily dismiss unmeritorious claims. While Ghana's Act lacks such a provision, Ghana may consider in its arbitration reformation expanded powers of the tribunal. Again, duties and powers of an arbitrator under Section 31 do not give the arbitrator, in the Ghanaian case, the power to dismiss unmeritorious claims summarily. It is important to note that this reform to the UK Act aligns the arbitration process with the summary judgment standard used in civil litigation in the UK, specifically Civil Procedure Rule 24. Both laws expressly state no real prospect of success as the main test for summarily dismissing unmeritorious claims or cases. Although Order 14 of CI 47 of Ghana is similar in substance to that of the UK Civil Procedure Rule 24, it does not have the specific words. In our bid to reform, we could use the same approach and legislate a test that reflects the current regime of summary judgment in Ghana to achieve the same level of uniformity. So, to conclude this first part, the authors outline that Ghana's ADR Act is generally aligned with international standards but lacks some modern arbitration innovations. Copyright holders Prince Kojo Tabiri and Godwin Selassie Osu. Background music credits Tappy Vibes South African Afrobeat Platinum Collection on YouTube. Medasi. Thank you.